We continue with the laws, the book of Mishpatim, of judgments. We're doing the laws, different kind of guardians, what it means. Okay, chapter 7. Just as a person may take any stipulation that he desires with regard to a purchase or a sale, so too he may take any stipulation he desires with regard to a rental. And we're dealing with rentals. A rental is a sale for a limited amount of time. So simply stated here, business law is what two parties agree upon. So if it's agreed upon that, you're renting, the bike for an hour, per hour you're paying, or you're renting it for the day, whatever the stipulations are between two people and person's renting from the renter, right? Whenever a person's sale of his property is upheld, the rental of his property is also upheld, will also be upheld. Conversely, when a person is not granted power to sell his property, he may not rent out that property, right? Let's say there's a question about this property. Does it belong to you? Does it not belong to you? Well, if it hasn't been granted you the power to sell the property, that means you can't rent it out either, right? Because it has to be yours. The only exception is when all he owns is the right to produce to the produce of the property. In such an instance, he may rent out the property, but he may not sell it, right? In other words, I bought the rights to the property, but I don't have rights to the property itself. So I could rent it out as a result. When a person rents out a house to a colleague for a year, and a leap year is declared, the extra month is granted to the tenant, right? So 13 months because you got an extra, right? Back in the day, it wasn't in the calendar. So it was something that was added by the court of law. So here, if it was added, so when is the year up? Well, a year means a year to date, right? Now an extra month, so that means the tenant gets the benefit. If by contrast agreement is made according to months, the extra month is granted to the owner, right? If I'm renting it to you for 12 months, not for a year, so then it's a benefit to the owner. If the rental agreement mentions both months and years, the extra month is granted to the owner. This applies regardless of whether the owner said a dinner every month, 12 denarii for a year, or 12 denarii a year and a dinner every month, right? Rationale is that the land is in the possession of the owner, and we may not expropriate anything from the owner of the land without a clear proof, right? Because it was basing it on 12 months, a dinner a month, right? So if there's an extra month that was added by the court of law, so then the renter would have to pay an extra dinner. Similarly, when the owner of the home says, I rented out the house for a specific time, and the tenant says, I rented it out without any specifics, or for a longer period, the renter must prove his claim. The onus is on the renter. If he does not prove his claim, the owner may support his claim with a shvus hesses and have the tenant removed from the home. Right. So, I mean, today everything's under contract. So, there's, but let's say it wasn't. Let's say it wasn't. So the onus is on the renter because the property belongs to the owner. You want to rent it further for a longer period or for whatever. So the onus is on you. Following rules apply when a tenant claims, I paid the rent that I was obligated for the house, and the owner claims I have not yet to collect it. The same rules apply whether the agreement was recorded in a contract or observed by witnesses. If the owner demands payment within 30 days of the beginning of the rental, the burden of proof is on the renter because he's collecting at the appropriate time. So it's a sign that he didn't get it. Alternatively, he must pay, right? If the renter did not prove, he may then have a ban of ostracism issued against anyone who took money from him. So the only thing he can do is that in the court of law, there's this called a ban of ostracism that since he, there's no proof here that he has. Today you get a sign, you get a sign that, I paid you, right? You get a receipt, exactly. So you have that, but we're talking about there isn't such a thing. There is no receipt. So then he would have to pay. But he can then have a ban of ostracism against anybody who took money inappropriately against that person. It's sort of just a deterrent that that person shouldn't lie if if he indeed's lying. Or the tenant may lodge a suit against the owner for the money they originally gave him as a separate claim and require the owner to take a Schwutzesses. So in the end, the renter can't do much, but he could make him take an oath, a rabbinic oath that he got paid, right? And that's something that people don't like to do. So, the guy's not telling the truth. That might be something to prevent him from saying or carrying out what he said. If the owner demanded payment after 30 days passed or even on the 30th day, the owner must bring proof that he was not paid. Otherwise, the tenant may take an oath that he already paid him the rent and thus he be released from any obligation. Seconds. Because it was the custom was that the owner is getting his rent within the 30 days. If it's only coming the 30th day or afterwards, and that's a sign that he got paid already. Therefore, the onus is on him. Similarly, if when the tenant rented the property, he stipulated that he would pay him the rent annually. If the owner demands payment within the year, the tenant is obligated to bring proof that he already paid because it's within the year, right? He's paying one time. If he demands payment after the year, even if he demands payment on the 29th of Elul, the owner is obligated to bring proof that he was not paid, right? Because he's waiting, kind of too long. And that's a sign that he got paid already because a person wouldn't put it off. The question is over here, since there's no other evidence, right? That's the point over here. There's no evidence, right? So then who's got the burden of proof to prove?
Receive the money.
Hmm?
The person should have received the money. The recipient.
The question is it on the renter or the owner? So we gave the distinction. It depends on what the time period is, right? And that's based on what the general principle back in the times, back in the day, of how people did things. Following rules apply. When a person rents out a house to a colleague for 10 years, has a rental contract composed but does not date that contract. If the tenant claims only 1 year passed from the time the document was composed, but the owner claims that the entire period of the rental agreement has passed and you have dwelled in the house for 10 years, the tenant is required to bring proof to support his claim. If he does not do so, the owner may take a assessment and compel him to leave the dwelling. Okay. Okay. Following rules apply when a person rents an orchard or it was entrusted to him as security for 10 years and it dries up. The tenant should sell the trees, purchase land with the proceeds, and benefit from the produce of the land until the conclusion of the rental contract or the period in which its security was entrusted. It's a safeguard against any violation of prohibition against taking interest. Both the owner of the orchard, the borrower, and the creditor are prohibited against taking trees themselves that became dried out or were cut down. And that. Following rules apply. When a contract for a rental or security mentions years without stating the number of years, the tenant claims the agreement was for 3 years and the owner of the land claims it was for 2 years and the renter or the creditor came and made use of the produce of the third year, we assume that the produce belonged to the person who made use of it unless the owner of the land brings proof that it's not so. Because he did it, so he's got to bring proof that it does. The owner has to bring the proof. Difficulty could arise if the tenant or the creditor derived benefit from the property for 3 years and the legal record became misplaced. If he said, I am entitled to the produce for 5 years and the owner of the land says the agreement only for 3 years, we tell the concerned parties, show the legal record. If the owner says it was lost, the tenant's claim is accepted, or it would have been claimed and he purchased it. Between the time for bond, the owner of the land says the agreement was unfavorable. Show the legal. If the owner says it was lost, the tenant's claim is accepted. For it would have, for if he would have claimed that he had purchased it, his claim will also be accepted since he derived benefit for 3 years. Since he was there for 3 years, so that shows he's got something to do with the land. Since there's nothing to prove, right? The contract's misplaced. So he could have said, I own the land. And because he was there for 3 years, that's a chazaka, he showed permanence on the land, right? And therefore he would have it would be his, the land. But he didn't say that. He just said, I have 3 years of rental. So we believe that because he could have said I have ownership. Right? There's nothing to prove here he doesn't have ownership. And he has 3 years on the land, which proves that he's been on the land. But the fact that now he says that he's 3 years, so we accept that and not 2 years. Following rules apply when a person brings his produce into his colleague's property without his consent or beguiled him into allowing him to bring in his produce, then left it and departed. The owner of the property may sell the produce in order to pay for workers to take it away and bring it to the marketplace. It is a pious conduct that the owner of the property to notify the court and rent a storage place or part of the funds. The owner of the property may sell the property in order to pay for the workers to take it away. Okay. It is pious conduct of the owner of the property to notify the court and to rent the storage place and funds and to prevent the destruction of the colleague's property, even if the colleague acted in a improper manner because he went and brought the produce into his property, right, without consent. Yet that would be the appropriate thing. The following rules apply. When a person rents a mill from a colleague on the condition the renter will grind 20 saw of grain for the owner every month as rent, and afterwards the owner of the mill became wealthy. Since he no longer needs to have the grain ground there, he asks the renter to pay him the equivalent of the wage he would earn for grinding the 20 saw. If the renter has wheat of his own or of others that he can grind instead, we compel him to pay the owner the wages he receives for grinding the 20 saw. Not to pay him would be an expression of the qualities of stone. For the renter does not have wheat. If the renter does not have wheat of his own customers, he may tell the owner, I don't have the funds. I'm prepared to grind grain for you as stated in the rental agreement. If you don't need this, sell the ground wheat to others. Similar laws apply in analogous situations. Okay, I'm going to stop here. Thank you very much. God bless you. I'm going to be away Sunday through Thursday till Thursday evening. I don't know what time I'm coming back Thursday evening exactly, but I plan to have the Tanya class, Chumash and Tanya probably. There won't be Sunday night class, and TRC will probably be Thursday night, something like that. Figure that out yet. All right. Thank you, folks.